Salam, my name is Najma Osman, and today I'd like to talk to you about renters' rights under Washington state law and the governor's special COVID-19 orders. But first, I want to make a disclaimer. I am not an attorney, and the following information should not be taken as legal advice. I am merely relaying a simplified version of Know Your Rights information provided by the advocates at CAIR Washington. This presentation also does not represent all aspects of the Washington State Moratorium on Evictions. If you have any questions about the following materials or need assistance with a landlord-tenant issue, please contact a housing attorney or the legal department at CAIR Washington. CAIR does not normally handle housing law issues, but if we are able to help, we will. If we are not able to help directly, we can put you in contact with a lawyer or an organization who can. As a renter, you have certain rights and responsibilities. Your lease is a contract, and in that contract, both you and your landlord have agreed upon certain rights and responsibilities. Before I explain what these rights and responsibilities are, I wanted to give you a breakdown of some of the housing law terms that we'll be talking about. For the purpose of this presentation, a renter or a tenant is someone who lives in or occupies a residential property for a specific period of time but does not own the property. This might be through a formal arrangement with a lease and or a landlord, or a management company, or through an informal arrangement with family or friends. A residential property is generally a property designed for or zoned for people to live in. It can include dwellings such as single-family houses, apartments, townhouses, condominiums, amongst others. For our purposes, when I say landlord, what I mean is the owner or manager of the property you're living in, who has the legal right to evict or take possessory action over the property. Here, the term possessory action means to take back a property from a renter, or essentially kick them out. For a landlord to do this, they cannot just remove your possessions from a property or change the locks. They must take certain legal steps. Those legal steps are called the eviction process. During regular times before and after the pandemic, and the special rules that were created for it, a landlord would have to go through the steps of the eviction process in order to kick you out, even if they weren't interested in trying to collect rent or other money owed. First, I will explain how this process usually works, and then I will talk about what has changed and what extra protections you have due to the governor's special COVID-19 order. Firstly, if a landlord wants to kick you out because you are behind on rent, or you've broken an agreement in your lease, or they just want to get their property back, they must begin by giving you notice. This will normally be a letter that explains the reason for seeking eviction. This might come in the form of a notice to pay, rent, or vacate, which means that you need to make a full payment immediately, or they will continue with the eviction process. A notice to comply or vacate, which means that you have to follow whatever rule or agreement in your lease that you have broken, or they will continue with the eviction process. A notice to terminate a tenancy, which is a notice that the landlord no longer wishes to rent to you. If you receive any one of these notices, you should consult with an attorney to make sure that your landlord had the right to take this action and to clarify your responsibilities and next steps. If you don't comply with the steps in the notice, then your landlord can serve you legal documents called an eviction summons and complaint. This states the reason for the eviction. This document requires you to respond to the complaint in writing. The next steps depends on you. If you do not respond to the landlord in writing, the landlord can ask the court to grant permission to kick you out without further notice. If you do respond to the eviction complaint, then the landlord can schedule a hearing with the court. You'll receive notice of when and where the hearing will be. In many Washington counties, you can get a free attorney from the government to represent you at the hearing. If the court rules in favor of the landlord, a sheriff's deputy will deliver an order that requires you to pay and or leave the property. You should comply with this order. If you don't, a landlord still may not change the locks or physically force you from the property. Instead, if you still haven't left after the sheriff brings this order, the landlord must request that the sheriff forcefully remove you from the property. However, due to the coronavirus pandemic, Governor Inslee released an emergency moratorium on evictions order. A moratorium generally means to put a temporary stop to an action. In this case, the moratorium applies to a temporary halt to the rules for eviction. The moratorium first went into effect on March 18, 2020, and has been renewed multiple times with slight changes. The current moratorium lasts until December 31st, 2020. CAIR Washington hopes and will continue to advocate that the order be renewed again after that. But please note that the following information is only relevant until December 31st, 2020. Under the current eviction moratorium, your landlord cannot give you any notices relating to eviction, including a notice to pay, which is a notice that you must pay any overdue rent or fees, a notice of unlawful detainer, which is a notice that you have unlawfully stayed in a property you don't own, a notice of termination, which is a notice to end your release, or a notice to comply or vacate, which means you must follow your lease agreement or leave. There are some exceptions, however, and landlord can give you a notice of eviction if they believe there is a risk to health, safety, or property. The landlord will need to fill out a legal document called an affidavit that swears to the court that if they don't evict you, you would be a significant and immediate risk to the health or safety of others or to the property. And landlord can also give you a 60-day notice to you if they plan to live in the property for themselves or if they plan to sell it. This moratorium does not mean that your landlord can't communicate with you, however. Any normal, lawful communication you would have had between you and your landlord before the pandemic can and should continue. You should still follow all the rules and agreements in your lease to the best of your ability. Additionally, and this is important, you are still responsible to pay your rent. It is very important that you understand that a moratorium on eviction does not mean you do not have to pay your rent. It just means that you can't be kicked out for it. If you are having difficulty making rent payments or expect that you may not be able to pay on time or in full in the future, please communicate your concerns to your landlord as soon as possible. In many cases, they may be able to help you work out a payment plan or provide some other assistance. You will continue to be responsible for all rent payments due during the time of the moratoriums, and you will owe any unpaid fees once the moratorium expires. Once the moratorium ends, your landlord can give you a 30-day notice of eviction, but they cannot deliver that notice and start the 30 days until after January 1st, 2021, under the current order. Please note that these are just some of the main protections under the Washington State moratorium and answers to your most frequently asked questions. This presentation does not include the national CDC order because the Washington State order is a lot more comprehensive. The federal order does not apply to Washington State residents as long as this moratorium is in place. Again, this information should not be taken as legal advice. If you would like to know more or have any questions regarding this video, please feel free to email me at nosman@cair.com. That is NOSMAN@CAIR.com. If you need any assistance with the landlord-tenant issue, please contact an attorney or the legal department at CAIR Washington at 206-367-4081. Thank you so much for listening. Feel free to share with family or friends who may benefit.